Hello everyone and welcome back to Thorough Newspaper Analysis, and we are here from LawSikho. Let's see what articles we will be discussing today from the Indian Express and the Hindu. Before we start this, once again, I would like to announce that now we have a separate Hindi thorough newspaper analysis exclusively in Hindi for all those aspirants that either are more comfortable in Hindi or they're preparing for the exams in Hindi medium or Hindi language. So you can view that as well on the very same channel of LawSikho itself, and it will be with the same name as Thorough Newspaper Analysis, but it will be written as in Hindi. And it will be covered also in Hindi. So with this, let's see that what all articles we will be discussing today. So the first one is from the Hindu, which is an editorial and is titled as Judicial Remedies for the Jammu and Kashmir Net Restrictions. So basically, as we know that since previous year, 5th of August, from the time Article 370 has been abrogated, there have been severe internet bans that are going on in the erstwhile state that is now, it is a union territory of Jammu and Kashmir. So basically it is talking about that and what all judicial remedies are available in this regard. Secondly, the Indian Express has this very nicely written, very small and crisp, but it is a very nice article which talks about, which is titled as Make It Less Taxing. Now, as we know that very recently, Prime Minister Narendra Modi has announced this very amazing, this initiative which is for the taxpayers, for the honest taxpayers. So in that light, how much will it be feasible and not? It has been discussed. And finally, we have the News and Flash column, which is our own initiative, wherein we will be talking about the small and pointer news points, which are primarily important for our prelims exam. Now let's have a look at the LawSikho courses that we have for you. And the center we have the Lord of the courses, which is the Judiciary Test Preparation course. So basically it will make it very well equipped to all the aspirants to prepare very well for this exam. And then you can go to the landing page of this very course, with the link to which is there in the description box, and you can download for yourself this free study material that is available. Then we have various other courses for CLAT, All India Bar Exam, etc. They can also be viewed anytime at the LawSikho page. Now let's see that what is the multiple choice question for the day. Which of the following is the national aquatic animal of India? First, olive ridley turtle. So it's a species of turtle. Second, dolphin. Third, hilsa, which is a fish. Or fourth, ghadial, which is a variety of the crocodile variety. So if to answer this question, if you know the answer, do write it down in the comment section below, and we will be covering the answer to this question in our this session to come. Now let's see that what is the descriptive question for the day. Discuss the various judicial remedies and steps that are available against the disproportionate internet ban in Jammu and Kashmir post Article 370. Now here post Article 370 we mean since the time Article 370 has been provoked or has been abrogated, like that is since last year. Mention the leading case laws to support your answer. So the answer to this question has to be written within a word limit of 250 to maximum 300 words, and it can be very easily jotted down in the comment section below. If in case any of the aspirants does that, we will be very happy to even review that answer. With this, let's start the discussion to our first article for the day, which talks about the right to judicial review, or basically discussing the judicial remedies that are available against the disproportionate ban on internet in Jammu and Kashmir. Now let's see that why at all we are discussing it again and over again. First of all, we know that it has been this 1 year anniversary on 5th of August. We know that we have completed this 1 year of abrogation of Article 370, and also it must be thought upon that the conditions which were prevailing in Jammu and Kashmir have still, till date, they have not improved to a bigger extent. The internet bans are still very severe. The people, the economy, education, they're still at stake. So basically the people over there are still not very satisfied and happy. And that is why it is the author is also quoted that after having heard 2 challenges on the validity of internet restrictions in Jammu and Kashmir since August 2019, the Supreme Court is yet to make a conclusive ruling. Now, many a time since, like we'll also discuss in this, that the judiciary, yes, has indeed played a very, very important and crucial and also active role in trying to restore the basic and fundamental rights that the people in Jammu and Kashmir have. But still, it has been one whole complete year since this has happened, and yet the Supreme Court, to say, has not been able to come to a concrete conclusion as to what would be the exact future specifically talking about the internet bans in the Union Territory of Jammu and Kashmir. Here it is very important for us as law students, or even as active citizens of this country, to understand that what were the basic outcomes of these various hearings that have taken place since that time, and what has been the impact, to say, on the internet bans of these hearings. Firstly, the very, very famous and probably the most important case that has been associated with this issue is the Anuradha Basin versus Union of India case, which is from this very January 2020. Basically, let's see that what was the ruling for that time being that has come out from this case. First of all, the court granted limited relief. This is the very issue, because then again we are saying that we have not still been able to achieve a conclusive ruling or a conclusive decision. And even in the case of Anuradha Basin also, the court had granted limited relief. Yes, of course, it was very important. It is still playing a very important role in providing and restoring the fundamental rights of the people in the valley, but still it is only a limited relief. Secondly, under this case, the Supreme Court directed the government to publish reasoned order. And it was through this case for the first time wherein the Supreme Court made it compulsory for the government that was functioning over there, and also of course the central government that has actually put those bans over there, to give a reasoned order. And in that, they were required, and they still are required, that if at all they are curbing the internet in a place or in an area, and they are not allowing the people to use a thing as basic as internet, they will have to give a reasoned order for that, which means that they will have to provide a proper reasoning for that. They would have to publish it in all the public places, so that the people know that why at all they are not being able to given this basic fundamental right that they actually deserve. And that is why it will be compulsory for the governments to give this rationale or logic behind their decision. Secondly, they will have to review the restrictions after every 7 days. So now this actually shows that how active the government must have been to keep on analyzing the prevailing situations. So even not even a time span of 15 days or even a month was granted, but the court said that after every 7 days the government shall make an introspection and shall make a kind of analysis as to, now after every 7 days, like today's day 7, then day 14, day 21, day 28. So according to that, they will have to analyze as to, is the internet ban that they have imposed is also proportionate to the situation prevailing now or not, because there might be a situation that after 15, 20 days or 1 month, the situations might have improved. So keeping that in mind, the internet should also be relaxed accordingly. So it should go into proportion, and it should not be at all disproportionate. Then the second one was Foundation for Media Professional case, in which the Supreme Court directed to set up an executive committee to review 2G speed restrictions imposed by the executive itself. Now basically, since March 2020, what has happened is that the government has allowed that, okay, fine, for the common people or the civilians who are residing in the valley, that is the Union Territory of Jammu and Kashmir, we would provide them with the access to 2G internet. Now this actually is very bizarre, and at times also it seems very ironical, because at one side where we are making to digitize India in the first place, and secondly we are moving towards the 5G spectrum or the 5G technology, people in the rest of the country are moving towards 5G, and people in the valley in Jammu and Kashmir, they are being given this, what should we say, this just a consolation price of 2G. Like, this is something that the entire country has left behind years ago. Now, can you imagine anybody using a 2G internet, and how feasible is it to use 2G internet in current scenario? It is just like you have just given something to them, but that actually counts to nothing. So that is actually, in this case, it had the Supreme Court held that it should be seen that how much is this order of the executive, and that is for the government, that they have given this 2G speed, they have allowed the people to use a 2G speed spectrum internet. How much is it viable, and how much is it actually adding to the plight of the people, and how much actually it is, giving them any kind of relief or not? And then, how did the restrictions and the pending trial affect JNK? Now let's see that what actually was the impact on Jammu and Kashmir and the people who were actually suffering due to this internet ban. Jammu and Kashmir economy suffered a loss of 40,000 crores in 2019. So, according to the Kashmir Chamber of Commerce and Industry, so the president of this chamber, he has told that since the time internet has shut down, we have had to suffer an economic loss of rupees 40,000 crores in 2019. Now, agreed that obviously national security comes above anything and everything. But then again, national security is also something that is backed up heavily with economy. If you're trying to secure your nation and it is hollowing up all in all inside, there is no point keeping any kind of national security. I mean, what are you actually securing people against? So that is why India, which had already entered a stage of weakened economy, in such a scenario, a loss of 40,000 crores alone in the year of 2019 to this one area of Jammu and Kashmir is very huge and devastating. And secondly, the 2G internet since March 2020 has failed to provide any respite. Now, as we know, since March itself, the lockdowns had come into being due to the COVID-19 pandemic. And in that scenario, most of us have relied totally on internet. Like, for example, if we take example of this very news analysis, it becomes so handy and feasible for all the aspirants to avail this, facility just through an internet connection and their smartphones or even laptops. Now, imagine a situation wherein a similar student is residing in the area of Jammu and Kashmir and is not able to avail this basic fundamental right of internet. And he has to, the schools are shut down, the economy is down, the markets had to be closed, there was lockdown all around. In such a scenario, just imagine the plight that the people of Jammu and Kashmir have had to suffer due to, first of all, this abrogation of Article 370, secondly, due to the ban of internet, and largely and thirdly due to COVID-19 pandemic. Now, in such a scenario, it is very, very important for us, all of us as citizens as well, and for the judiciary and the government as well, to realize the problems that these people have to face and to come to a solution as soon as possible. Now, here, what were the arguments in support of the Supreme Court's differential approach were like this? Because see, what has happened is that the Supreme Court is not at all allowing any kind of subjective decisions. Basically, here we need to understand that what do we mean by subjective and what do we mean by objective. Just like in our exam, when you have an objective kind of question, that is like a multiple choice question, you have to come to one concrete answer. You can't really, deviate or beat around the bush. But in a subjective thing, you can, in some or the other way cover the issue, but still not reach to the accurate one. In the similar sense, subjective decisions that are taken by the, so basically it is said that the government says many a times that subjective decisions cannot be taken or presented by the judicial body. But that is the very thing that India did not allow to happen even while we were framing our constitution. The very idea that we had Article 32 as a judicial remedy available to the people, wherein they can directly approach the Supreme Court if in case their fundamental rights are being abridged, that was the very point when we, brought down this entire ambiguous idea that decisions cannot be taken by the judicial body. And even the constitution framers, as we said, they rejected in the English public law, and thus we incorporated Article 32. Thus also in the ADM Jabalpur case, it was held, though this was the thing that we used to believe until ADM Jabalpur case. But then in the case Swamy case, it was completely overruled, and it was said that the judiciary very much is entitled to get involved into such issues. And secondly, it is contended that the courts do not have the competence to review matters that are related to national security. Now, this is basically, just to say that if it would definitely mean that the courts would not be allowed to intervene into any matter which is crucial or complex in nature. Now, if at all this is to happen, what is the basic idea of having judicial system in a country? Imagine. And this is not the case. Courts definitely are very much entitled and righteous to move into the matters of national security. And it is not like for the first time that the court is making such initiatives. When there was a case of cryptocurrency that came in, we all remember the cryptocurrency thing, the Bitcoin thing. That was also, in that also the court, it played a very active role, and it banned all this cryptocurrency. And second, in the case of even Swamy, where linkage of Aadhaar, that was also a point when national security was brought into question, and then the Supreme Court gave its very golden decision or verdict on that matter. So many a times the Supreme Court has already, and the various other courts like for the matter, but specifically talking about the Supreme Court, it has taken very substantial decisions regarding the national security and also as money laundering. So these two contentions are just, they're not at all logical, and that is why they should no way be able to stop the courts, and especially the Supreme Court, to take a concrete decision in this issue as well. Now here is a 4-step test which was given. So basically this should be known that the proportionality test came through which case. So this was through the case of Anuradha Basin versus Union of India 2020. In this case, a 4-step justification came that first of all, the restrictions that you are applying, they should be in pursuance of a legitimate aim. Because here, now since the government says that this is important for the national security, so fine, this can be done, and these restrictions can be allowed. But then again, further, these restrictions are suitable to achieve the aim. Now, obviously, your aim is very much legitimate, your aim is very righteous and judicious, but you should make sure that the restrictions that you are choosing to reach to this aim, or to achieve this aim, these restrictions are also suitable to achieve. So they're not very harsh in their nature. Then we should make sure, next step is that we should make sure that there exists no less restrictive alternative, that you have only and only this choice, and there is no other alternative, or there is no other way that is available for the government or for the authority to take any other method, and that is why it is compelled to take this restrictive action. And finally, adverse impact is proportionate to benefit. Now, you should make sure, like in this example, you should make sure that in the name of national security, the internet ban that you are imposing on the people, so this suffering that they have to face, and not only this, basically, the economic suffering that they have to face in the field of education, in the field of basic civilian lifestyle also they have to face. So you should make sure that the totality of this suffering that the people or the authorities, whatever, are the stakeholders, they have to face, they are in proportion with the benefit that you would gain. Like, for example, the government says that fine, we are okay to bear such losses, but we cannot bear to increase terrorism in the valley, or increase such illegitimate activities in the valley. So till the time this suffering is in proportion or is equal, or to say it can compensate the benefit that you are getting, then till then it's fine. But the time, if there is a time when the suffering is too much and the benefit that you are able to get through that suffering is just a little bit, then definitely the proportionality fails, and that should not be the way that you are adopting to reach that particular aim. So this was a very important article. That is why we discussed it in a quite exhaustive manner. Now let's see the second one, which we'll discuss into a very short one, because it's only a very simple argument. Basically, it is after the Prime Minister Narendra Modi has launched the Transparent Taxation Honoring the Honest platform, wherein basically Prime Minister Narendra Modi has said that what we will be doing is that we will prepare a specific taxpayers charter, and also there will be some other features like faceless assessment, faceless appeal, as in to avoid any means of corruption, and so that we are able to reward the people who are honestly paying their taxes. But after that, there was a tweet which came from MyGov India. Basically, MyGov India is the official government handle on Twitter, and whatever announcements that are made by the official government of India, they come through this Twitter handle. So basically, there was a tweet from MyGov India which proposed to increase the list of reportable financial transactions. Now we'll discuss this into detail as to what are reportable financial transactions, because this is the very essence of today's discussion as well. But then later on, this tweet was deleted. So that is actually, making the complete, this controversy to say. So first, let's see that what is the reportable financial transaction. So basically, they're also known as statement of financial transactions, and they are available under Section 285BA of the Income Tax Act 1961. Now, here are a few points which you should know. Firstly, we'll understand what is the SFT. Secondly, which provision has provided for SFT? So this is Section 285BA of the Income Tax Act. Remember, this is not the Income IT Act, like the Information Technology Act. This is obviously the Income Tax Act 1961. And to submit the income tax, it has to be submitted to the Income Tax Authority. So generally, a statement of financial transactions simply mean that there is an authority that is compelled, or which we should say it has a duty to provide every year a list of various financial transactions. Now we'll break it up and then try to understand. First, Statement means any report, any publishing, anywhere, a list particularly. So very simply, just take it as a list, okay, wherein you have prepared a list of what? Financial, that is relating to your expenditure, your income, wherever you have spent your money, from wherever you have incurred some amount. So anything that is related to some gain, profit, or some loss, anything for that matter, which is related to financial terms. And thirdly, transactions means this very thing: giving of money, taking of money, investing your money into something, taking a loan, or spending somewhere you have availed any kind of service, wherever. Like for example, even if you get a subscription done of Netflix, for that example, okay, so even that is a kind of transaction, because you're paying something and then you're availing a service. So that is also a kind of transaction. When you go and buy a movie ticket, that is also a kind of transaction. If you go to a bank and you are taking up a loan, that is also a kind of transaction. So anywhere where you are using your money, now be it like in cash or cashless transaction, but wherever you are spending or earning some money, that is called as a transaction. So basically, under the SFT, or the statement of financial transaction, the authority is required to prepare an entire list of such financial transactions that have taken place in an year, so that the government and basically the income tax department is it becomes acknowledged. It now knows that how many people have spent how much of money in what kinds of works. That would actually help the government to increase the tax base. Very simple to understand. Tax base is simply that out of the entire population of a country, how many people are paying taxes. For example, if there are 100 people in the country and only 20 of them are paying the taxes, 20 is the tax base of that country. In the case of India, it is very disheartening to know, but yes, in the entire population of 130 crores, can you imagine how many people are actually paying taxes? Only 1.5 crores. So can you imagine that how much narrow tax base do we have? So this basically is the tax base, that out of 130 crore people, only 1.5 crore people are paying taxes in India, and thus the tax base in India is very narrow or very small. And that is why it was contended that it might help. Now if we are able to record and report more and more financial transactions, we will definitely get to know that how many people are spending how much, and that would help in increasing the tax base. So this was all for this we have discussed. But then we have to understand that what are the problems if we do this. Basically what happens is that already a very small number of people are paying taxes in India. What will happen is that since these people are already listed and they're already in the eyes of the income tax department, so the transactions that these people are making, they will be more into, they will be highly reported. And then these people who you actually wanted to, reward through this honoring the honest taxpayer scheme, they will actually be compelled to pay now more of the taxes. Because obviously, take for an example, there is a government employee. So the salary of that government employee is directly coming from the government. So obviously there is any chance that he is able to hoard the taxes, or he's not paying the taxes or evade the taxes, because obviously the government knows that I am paying, for example, 2 lakhs to this person, so accordingly this much amount of tax should be deducted. And when he receives his salary, he already has this deducted amount. So basically if he has to get 30,000 deducted, so he already receives 1,70,000 only. So there is obviously no chance that he can evade a tax. Now in such a scenario, government already knows that this person, government employee, who mostly are honest taxpayers, because they are getting the salary from government itself. Now the government already knows what financial transactions this person is doing, and it would be very easier for the government to tax him on these transactions, and this person will be more vulnerable towards getting his taxes cut. Whereas the other people who are working into some private businesses or private entities, who are working on for some businesses, who do not really put forward their real income, they can easily escape again. So basically the very idea and aim that is to be achieved through this initiative will be put down if we do so in this regard. So this was all for the day, and now let's discuss what do we have for news in flash. The proportion, first of all, we have Project Dolphin. So basically, dolphin is the national aquatic animal of India, and one of the species that is very famous in India that is found in the Ganga River is the Irrawaddy dolphin. That also can be a very potential prelims question. So basically, on the 74th Independence Day, PM Modi has announced for Project Dolphin, which will work for the conservation and protection of dolphins in India, and this will also help to boost the biodiversity and tourism. And second, Pandit Jasraj passed away. So basically, Pandit Jasraj, who was he? This can be a question. He was basically a very, very famous classical vocalist, and he belonged to which gharana? Mewati gharana. Basically, we have a lot of gharanas when we come to dance forms as well as classical music. So he belonged to Mewati gharana, and he has recently passed away. So he was honored with honors such as Padma Shri, Padma Bhushan, and Padma Vibhushan. So these should be remembered and kept in mind. With this, we are done for today. We hope it was a good session for you. Stay tuned with LawSikho for such more sessions to come. Thank you so much.